I'm also Assistant Director of the Montreal Police Force. This is a police force that has more than 4,600 members, a population of over 1,800,000 people, a very varied population, both when it comes to ethnic origins, poverty or levels of poverty and wealth in the island of Montreal. And the issue of drugs is a very important one. I also represent the Montreal Police, as I say. When we look at the action being taken in matters relating to drugs and the way in which the Canadian Police Association of Chiefs of Police have been working, I would say that our approach is quite similar. And I would like to talk about the four main aspects. First of all, we do research in an attempt to better understand the causes relating to the consumption of drugs. We've conducted research both within our organization and outside by the four universities that are to be found in the island of Montreal. And I'd like to draw your attention to research that was done recently where it became clear that our criminals are less interested in fraud, theft, break and enter, and there has been increased movement from criminals to in activities such as trafficking drugs. This reinforces the importance of activity aimed at dealing with drugs. We've also been working on communications. We talk more about education. We've been attempting then to raise this with the various partners, the types of intervention and support that can be provided. It's important to educate and make the population aware. This is part of our general communications strategy. The third pillar then is prevention, and this is something absolutely essential in order to be efficient in dealing with drugs. Not only should we increase empowerment, but prevention, particularly when we are dealing with consumers. People who have health problems, who are drug addicts. I think that it's through prevention that we can help them overcome this difficulty rather than treating them as criminals. And the fourth aspect is the repression, whether it be in Montreal or in Canada in general. The police associations give priority to dealers and traffickers. And I think that Bill S10 does allow us to deal with this particular issue in view of the fact that we'll be adding minimum sentences for people who are affiliated with criminal organizations. And I think it's important for us to establish this as a priority. Intervention with the dealers and this emphasis that has been given to prevention when it comes to consumption. The Canadian Police Chiefs Association takes the same position. So we've been attempting to work together with the various partners, community groups, with detoxification centers, with the police services and consumer groups. We've been focusing particularly on dealers. And I'd like to deal more specifically with provisions in Bill S10. When it comes to the proposed version of Clause 2, that is minimum sentences for offenses carried out by a criminal organization, under a criminal organization, or whether it's violence or the use of weapons. We consider this to be an aggravating factor that must be taken into account when such an offense is committed. With my experience, I've been working on this for 27 and a half years. Particularly narcotic drugs. And I would say that these are factors that are already considered by the prosecutors and the judges in determining the sentence. But the fact that it is mentioned in the legislation, I think, will help, particularly when it comes to a minimum sentence in use of a firearm, for example, in the commission of an offense. We are favorable then to this provision. When it comes to the second part of Clause 2, that is an offense in the vicinity of a school or within a prison. I think that legally, perhaps there should be some clarification. There was a recent decision relating to Clause 170 relating to loitering. Reference was made to school grounds, playgrounds, and public parks. We found that this definition was far too general, and it was contrary to Article 7 of the Charter of Rights and Freedoms, so perhaps an attempt should be made to consider the legal implications of this decision. In case of Clause 3, where minimum sentences will be imposed for over or under a kilogram, we are in perfect agreement with this. We consider this already to be an aggravating factor in most narcotics cases, but it will give a clear guidance to people who commit such an offense will know what to expect, and then I think it will also help in in accelerating the treatment of these files in the courts, particularly such as the use of firearms as well in the commission of an offense. In case of Clause 4, when there is a relationship with real estate, there's been an increasing number of offenses relating to grow-ups. So we think it's important to have an aggravating factor that will allow for a minimum sentence in cases such as these, because I think that the data relating to the number of offenses within the northern part of Montreal, and this is in Montreal itself, there are large numbers of houses that are completely transformed, have been demolished, and the Quebec police force as well, and police throughout Canada in rural areas are faced with farmers who are having trouble with outdoor grow-ups as well. With respect to clauses 1BI, 4I, and this, it was not mentioned that there was in the case of trafficking or dealing, whereas in the other elements, I think that for the last four elements, it should be specified that this is an offense relating to trafficking. In the case of Clause 5, the only question raised by members of our legal services was whether there should be, the notice should be written or oral. Should it be a written notice, or is an oral one sufficient? A verbal one sufficient? There are also references made to drug courts. According to the research that we have we've had done so far, this information is available only in 6 cities, and none of these cities are to be found in Quebec. So I think that there should be an equitable and equal treatment throughout the country. With respect to the other clauses in this bill, there is nothing particular that we have to draw to your attention. So basically, as I said, both the Canadian Association of Police Chiefs and the Montreal Police Service, we are favorable to Bill S10 that will give us additional tools to deal with the problem and will allow us to be more efficient. We think that certain sections of this bill will enable us to expedite the judicial process in view of the fact that criminals will know exactly what their minimum sentence there will be for these offenses. Thank you. We're certainly going to have questions for you.
Conference, and we're going to ask Mr. Bratzer for his statement. The floor is yours, sir. Can you hear me?
Yes, Madam Chair, I can hear you.
And did you get the translation from what was said in French? Were you able?
Yes, Madam Chair, I was able to hear it. Thank you.
Splendid. Okay. Go ahead.
Thank you. Thank you so much for having me here today. I have listened carefully to the two presenters before me, and I certainly appreciate their perspective. I work as a police officer in British Columbia, However, I am here today while off duty representing the international nonprofit organization Law Enforcement Against Prohibition. Now, since my first committee appearance last year, several high-profile individuals have publicly joined Law Enforcement Against Prohibition. This includes Vince Kane, who was a RCMP chief superintendent until he retired. He was also the chief coroner for the province of British Columbia. It also includes Justice Ross Lander, a retired BC Supreme Court Justice, as well as Bill Vandergraaf, a retired staff sergeant with the Winnipeg Police Service. As a representative of Law Enforcement Against Prohibition, I would like to update the committee on several key developments that have occurred since its contemplation of Bill C-15. First, in March, the Urban Health Research Initiative of the BC Centre for Excellence in HIV/AIDS released a report. The report is titled Effective Drug Law Enforcement on Drug-Related Violence, Evidence from a Scientific Review. The authors reviewed available English language research about drug enforcement, and upon reviewing these studies, they identified 15 studies that specifically examined the connection between drug law enforcement and its effects on violence. 13 of these studies, or 87%, showed, and I'm quoting here, a likely adverse impact of drug law enforcement on levels of violence. That is, most studies found that increasing drug law enforcement intensity resulted in increased rates of drug market violence. The second important development that I would like to share with you occurred in July with the announcement of the Vienna Declaration. This was the official declaration of the International AIDS Conference, attended by some 20,000 scientists, public health physicians, and other healthcare professionals. The declaration stated that the criminalization of illicit drug users is fueling the HIV epidemic and has resulted in overwhelmingly negative health and social consequences. The declaration called for a full policy reorientation. Taken together, these two events give us some idea of the terrible consequences that this bill will have in terms of community safety and public health. And in this context, I would like to explore Section 7 of Bill S10, which amends Schedule 1 by adding numerous drugs that were previously listed in Schedule 3. This section illustrates that Bill S10 is also a drug possession bill aimed at drug users. There is going to be a massive shift in which all of the amphetamines, as well as flunitrazepam, as well as GHB, are going to move to Schedule 1. Methamphetamine, of course, already moved to Schedule 1 from Schedule 3 back in 2005. Given this trend, one can project that we may be moving toward a time in which more and more drugs are listed as Schedule 1 substances, the very worst of the worst drugs. So I asked the members of the committee, what will this mean for us as a country, as a society, in terms of our ability to differentiate more harmful drugs from less harmful drugs? And this brings me to my closing remarks. Law Enforcement Against Prohibition remains opposed to mandatory minimum sentences for drug offences in Canada, but if this bill is going to pass, we hope the committee will see fit to add sensible amendments. One of these amendments could include an exception for MDMA so that it can remain a Schedule 3 substance. Presently, it is listed as number 8 in the list of amphetamines as N-methyl-3,4-methylene dioxyamphetamine. Another amendment could also include an additional report to Parliament at the 5-year mark in order to examine the potential benefits as well as the many drawbacks of this legislation as it will be implemented. Law Enforcement Against Prohibition would also support any other reasonable amendment that would encourage a public health approach to drug policy in Canada. Honourable Senators, thank you very much for your time.
Thank you very much indeed, Mr. Bratzer. Now